Hello, ladies and gentlemen. More about the whole January 6th thing, mostly due to what came to Dominic Pizzola. Yeah, there's quite an interesting tale to this, to where I think the government may have been actually involved into all this. Now, remember, I did a video specifically talking about how the government was withholding evidence and stuff like that was been going on, and this here kind of shows exactly what has been going on. I'll go directly into it. This might be a little bit long video because I have to read the whole document to you because, well, yeah, you guys get the whole picture. United States of America versus Dominic Pizzola. Defendant Pizzola's motion for dismissal with prejudice or in the alternative mistrial regarding recent revelations on Tucker Carlson and associated testimony and the discovery of massive Brady and Jennings violations and violations of due process and the Sixth Amendment, with included memorandum law. Is that Brody law? I may believe that I was talking about, that we're mostly talking about, that I was talking about in the previous video. Defendant Dominic Pizzola, by and through his undersigned counsel Roger Roots and Stephen Metcalf, hereby moved the court for dismissal of the indictment in this case with prejudice due to recent revelations on the Tucker Carlson show and associated testimony on Thursday, March 2nd, as well as due to Jennings and Brady violations revealed on March 8th, which established that the prosecution has been monitoring attorney-client communications of defendants, destroying evidence, and doctoring and fabricating evidence involving confidential human resources. During trial on Thursday, March 2nd, 2023, the prosecution in this case presented Mr. Kevin McCuber, Deputy Clerk of the U.S. House of Representatives, as a prosecution witness. McCuber is the highest-ranking official of Congress to testify in this case. Mr. McCuber was called to testify starting on March 2nd at about 11:45 a.m. Mr. McCuber has been employed by the House of Representatives for over 2 decades. He has vast knowledge of congressional politics and was watched hundreds of representatives interact with the House chamber. McCuber's daily duties include being in the House chamber where he helps run the proceedings of the House and records entries in the official House Journal logs. During direct examination, McCuber showed the jury with the video recordings of both the Senate chamber and the House chamber graveling into recess on January 6, 2023. Prosecutors have claimed that defendant Pizzola and co-defendants caused Congress to go into recess by entering the Capitol on January 6, and in fact, several counts of Pizzola's indictment, including counts 2 and 3, require proof that Pizzola and co-defendants caused the recess of Congress on January 6th. During the cross-examination, Mr. McCuber was asked about the recess or obstruction of the joint session of Congress. During questioning by undersigned counsel Roots, Mr. McCuber admitted that there was no need for Congress to recess on January 6, 2021. Mr. McCuber testified that protesters have frequently, at least 6 times, in his personal experience and opposition demonstrated in the actual chamber and on the floor of the U.S. House. McCuber testified that each time the protesters were removed and congressional session continued, yet on January 6, 2021, no demonstrators ever entered the House chamber at all. For over 2 years, the government has claimed that some of the demonstrators who were in the halls and outside the U.S. Capitol building obstructed an official proceeding in violation of 18 U.S. U.C. I apologize. 1512. Yet the government has steadfastly refused to identify in what way any of those defendants directly caused a recess of the joint session, despite repeated demands for disclosure of this information as potentially exploratory evidence whose disclosure is required under Brady v. Maryland, 373 U.S.C. 83, 1963. So what we're seeing here is that there is no evidence, that the evidence was withheld. We need actual justice. Now, as I would say that I don't know whether this man has truly been done it, right? I don't know if we have the full evidence of what he really did, but put this in the limelight, as what Tim Pool would say. If this man actually did commit crimes or what have you, but you've seen the actual government withhold that information, then Well, it's a violation of the Sixth Amendment and the Brady's Law, and we have other issues that would have him exonerated, or rather, not be put in jail because the government withheld information. You can't do this because that violates the Sixth Amendment rights and all the other stuff that is a problem here. Now, granted, I am not a lawyer, and I'm not proclaiming to be. Hoping Nick Rocado goes over something like this. Would like to be going on a show with him for it to kind of understand what's going on here, because what we're seeing here is a massive violation of somebody's rights and a huge issue. The government is doing this horrendously. And it says, what about the Senate chamber? Even the House could have continued without recess on January 6th. What about the Senate? Evidence in this trial has established that for a brief time, around 2:30 to around 3 p.m. on January 6th, protesters did in fact breach the Senate chamber. Inspector Lloyd of the Capitol Police testified that a protester managed to leap down on the lower floor from the balcony, and that the protesters then opened a door to let other demonstrators into the Senate chamber. Never during this trial has there been any evidence of any raucous or extremely destructive or violent demonstration in the Senate chamber. There have been a few images of demonstrators sitting on chairs or standing in the well of the Senate, and that is true, since we've seen in the videos that where there is not really anything that's going on here in the Senate. Most people are walking about, some people are talking on microphones, some people are just standing there. There was no actual violence in the legitimate chambers. We've seen the video of this. Then came the Tucker Carlson show on the evening of March 6, 2023. On March 6, Tucker Carlson released shocking footage from January 6, 2021 that showed Ekunan shaman Jacob Chansley walking calmly through the halls of the Capitol with two Capitol police officers. At one point, one of the officers appeared to try to be opening a door or elevator and then turns and leads Chansley in another direction, which I told on one of my videos, I may believe yesterday, about this. Later in the video clips, Chansley is walking past 9 police officers gathered in the hallway intersection. Chansley and his police escorts walk right past the 9 officers without any resistance. And then Tucker Carlson presented footage of officers calmly escorting Chansley and apparently other protesters into the Senate chamber. The Washington Post wrote that Albert Watkins, Chansley's attorney through sentencing in November 2021, said he had been provided many hours of video by prosecutors, but not the footage which Carlson on Monday night. He said he had been not seeing video of Chansley walking through Capitol hallways with multiple Capitol police officers. What's deeply troubling, Watkins said Tuesday, is the fact that I have to watch Tucker Carlson to find video footage which the government has, but chose not to disclose despite the absolute duty to do so, despite being requested in writing to do so multiple times. So, what we're saying here is, again, that the government has withheld information from this guy's specific case. Now, we know that they will hold information from other cases and stuff like that, like from Chansley or what have you, and all these other people that are on court. But also, with this guy, they also withhold information. It's not from these one people, right? Just from the other people aside from this case. It was also from him. They withhold information from this guy as well. And even the lawyers from this defendant's lawyers repeatedly asked multiple times for the information, and the government did not give them it, which was a violation of the Brady Law. Pizzola likewise has a right to the same footage, yet the government has withheld it. The most disturbing footage of all, from the perspective of Pizzola, is video shown on Tucker Carlson of Professor Chansley kneeling in a prayer amid a group of 24 demonstrators and cops in the Senate chamber. Chansley is shown giving a respectful prayer of thanks to the Capitol Police officers for letting us into the building. This footage is plainly exculpatory, as it established that the Senate chamber was never violently breached and in fact was treated respectfully by January 6 protesters. To the extent protesters entered the chamber, they did so under the supervision of Capitol Police. The senators on January 6 could have continued proceedings. It was not Pizzola or co-defendants who caused the Congress to recess. Congress entered its own proceedings. This Brady evidence was requested many months ago in this case. Co-defendant Rail demanded all information regarding reasons for Congress recess as early as November 23, 2021 at docket 230, while Brady operatives do not extend to the entirety of the government. They do include investigative agencies or agencies closely related to who knew or should have known that information would have been material to a prosecution arising from their direct involvement. Here, the U.S. Capitol Police are directly related and fully aware of the events of January 6, 2021. The Supreme Court in Brady held that the Due Process Clause imposes on the prosecution an affirmative duty to disclose exculpatory information to the defense. under Brady, suppression of evidence material to either guilt or punishment, whether or not there is bad faith on the part of the government, constitutes a due process violation. However, the Brady Doctrine requiring disclosure of obligatory information has been extended to situations where a division of police department not involved in the case has information that could easily be found by prosecutors if they sought it out. See Brooks 296. All right. Finally, a clear and flagrant Sixth Amendment violation was revealed in court on March 8th, which screams for dismissal or eternally a mistrial to be declared immediately. Then, in the afternoon session of trial on March 8th, it was revealed that the FBI has been monitoring privileged communications of co-defendant Rail and his attorney, and discussing Rail's case strategy amongst each other. These revelations came out as co-defendant Norton's counsel Nick Smith cross-examined FBI Special Agent Nicole Miller. Smith revealed that a secret hidden tab in the FBI spreadsheet showed some of Agent Miller's emails in which the FBI agent admitted fabricating evidence and following orders to destroy hundreds of items of evidence, which has already been shown in my previous video. You guys should take a look at that. If justice means anything, it requires this case to be dismissed. A Sixth Amendment violation cannot be established without a showing that there is a realistic possibility of injury to the defendant or a benefit to the government as a result of the government's intrusion into the attorney-client relationship. So, that's pretty much it. But I'll keep on going anyways. Where was I? Here we go. Okay, so it says, here, in the Norton case, confidential attorney's client trial defense strategy and position was wrongfully obtained by the government about which was overheard. Shared, utilized, where potentially 338 items of evidence were ordered to be destroyed. So, such information benefited the government, and consequently each of the defendants, including Pizzolo, suffer substantial prejudice. Any deprivation of the right to counsel and to be for a fair trial is in itself a basis for annulment of a determination resulting therefrom the U.S. Constitution, Sixth Amendment. My apologies. My mouth is getting a bit dry here. To require the defendant to show prejudice, it would of course implicate and most likely intrude into the attorney-client relationship, a consequence hardly commendable. It is apparent that the only way a defendant should have to show prejudice would be to disclose that what evidence he and his counsel would have perceived. Therefore, to require the defendant to show harm would necessarily require the disclosure of attorney-client communications. As a result, it is implicit that an intrusion into communications protected by the attorney-client privilege would be prejudicial to the defendant. Mere possession of the prosecutor of otherwise confidential knowledge about the defendant's strategy or position is sufficient in itself to establish deterrent to the criminal defendant. Moreover, it would be virtually impossible for the court to sort out how any particular piece of information in the possession of the prosecution was consciously or subconsciously factored into each of its decisions. Mere possession by the prosecution of otherwise confident knowledge about the defense's strategy or position is sufficient in itself to establish the judgment to the criminal defendant. Such information is inherently detrimental, unfairly advantageous to the prosecution, and threatens to subvert the adversary system of criminal justice. As highlighted in a recent defense findings of Special Agent Miller's communications, the government is responsible for deriving evidence from such communications. Prejudice may be presumed because of advice received as a result of a defense disclosure to counsel must be insulated from the government. So, yeah. This is what's going on here. This is insanity. The fact that the government is doing this is insane in itself, and the fact there is no other issue is a huge problem. Alright, so we have this from Rochester, New York. A man arrested and charged with destroying property and obstruction of congressional proceedings. So it says that Dominic Pizzola, also known as Spaz and Spazzo of Rochester, New York, was charged by a criminal complaint with one count of obstruction in an official proceeding in violation of Title 18 United States Code sections, one count of destruction of government property in violation of Title 18. United States Code Section 1361, and one of knowingly entering or remaining in any restricted building or grounds without lawful authority in violation of Title 18. So, yeah. It shows that Pizzola is smoking a cigar inside the building. In that video, Pizzola can be heard saying words to the effect of, "Victory smoke in the Capitol, boys. This is fucking awesome. I knew we could take this motherfucker over if we just tried hard enough." Alright, so, like I said, they have this stuff in these sayings. And again, I don't know whether this guy's innocent or not. However, if they are withholding information and he's still guilty, that's still a problem. It's the Brady law that they're violating, and it's the U.S. government. So again, we can't do anything. So no precedent for Dominic Pizzo's argument for release from jail. So so obviously this guy tried to be released earlier, and they denied it or what have you. So yeah. The United States government is doing something incredibly nefarious. It's the things that we would only see in obvious communism type, communism/socialist type governments. Plain and simple. We need justice for this man because this man has been obviously been prejudiced against. The government, the FBI, needs to be destroyed immediately. End of discussion. Alright guys, that's it for the video. Like, subscribe, share. As always, take care.